We are still at the stages of the writing of the written addresses in the presidential election petition court sitting in Abuja. Today in this video, I am going to bring to you summary of Labour Party and Obi's reply to INEC's final written address. Labour Party started by saying that it is difficult to comprehend why INEC would abandon its primary responsibility of being an electoral umpire and proudly put on the toga of a candidate in the election it conducted. They further stated that INEC didn't release relevant documents to Labour Party despite court order. They continued by raising three issues for determination. The first was as regards to whether Bala Ahmed Tinubu and Shettima were qualified to contest. The second is on non-compliance of INEC to electoral guidance. The third is on qualification vis-a-vis non-compliance. On the first issue, they defined money laundering and mentioned the fact that its nature and character clearly involves dishonesty on the part of the person who engaged in money laundering, as in the case of Bola Ahmed Tinubu. Labour Party argued that APC in their final address were wrong to say that a conviction must exist before a person will be disqualified from contesting for the office of the president. They also argued that the US district judgment they tendered was in full compliance with the law. They further argued that by the express meaning and intendment of Section 137, subsection 1d of the Nigerian Constitution, a person who, even though not convicted, have forfeited property on account of criminal conduct should not aspire to be allowed to occupy the exalted office of the President of Nigeria. On disqualification of Shettima, they relied on Section 142 of the Constitution, which provides that a person shall not be validly nominated unless he nominates another candidate as his associate. They also relied on Section 34 of the Electoral Act, which is on double nomination, and argued that Shettima's nomination as a senator was never withdrawn by law. They argued, relying on PDP versus Degi Eremienemo, that for the reason given, both candidates should be disqualified, reason being that their joint ticket is vitiated by the disqualification of Shettima. On the second issue, they argued that through the documentary evidence before the court and the unchallenged expert and technical evidence of Labour Party's witnesses, Labour Party has proved that the non-compliance by INEC with the relevant provisions of the Electoral Act and the subsidiary legislations substantially affected the outcome of the questioned presidential election held on 25th of February 2023. Furthermore, Labour Party argued that the election manual and regulation is a subsidiary legislation which has the force of law. They have their origin from the Constitution and the Electoral Act. They argued this relying on Falake versus INEC, stating that INEC should have complied with its manual as regards transmission. As regards the Federal High Court judgment relied on by INEC, Labour Party argued that the decision in Oyetola versus INEC, which is a Supreme Court decision, overrides that. In the said case, the court held that while there is no part in the Electoral Act and INEC guidelines that require that the election result of a polling unit should during the poll be transmitted on the spot to the INEC National Election Register database, the regulations provides that the beavers be used to scan the complete results in Form EC8A and transmit or upload the scanned copy of the polling unit result to the collation system and INEC result viewing portal (IREV). In addressing the testimony of witnesses, Labour Party argued that INEC, in an attempt to discredit the evidence of witness PW7, described her as a person of interest in the outcome of the proceedings. However, she tendered documents which are publicly accessible, and they also mentioned that INEC did not deny hosting its servers. They further argued that INEC's witness in paragraph 27 and 28 of his witness statement on oath misleadingly and incorrectly claimed that all polling unit results at the close of polls were immediately or timelessly uploaded. And they went ahead to state that the downtime encountered on the application lasted 4 hours 50 minutes until it was resolved, and the first presidential result was successfully uploaded at 8:55 p.m. on the 25th of February 2023. They further argued that believing that the blood-certified copies which INEC's sole witness claimed to be the copies of the original is like believing that you can harvest apples from palm trees or apples from pawpaw trees. They further argued that the unchallenged expert evidence of the Labour Party's witnesses, including the documentary evidence before the court, have established that the non-compliance of INEC in the circumstance of the instant petition were not only substantial but grievously affected the outcome of the presidential election. Still on the evidence of INEC's sole witness, they mentioned that in a futile attempt to justify the technological glitch, INEC's witness RW1 tendered an alleged AWS CloudTrail logs showing the touted technological glitches, but on cross-examination his evidence showed that the evidence he tendered didn't meet the criteria a CloudTrail should have. A cloud trail should ordinarily have an event time, event source, source IP address, etc., but the one tendered by INEC's witness did not have the most of the criteria. On substantial non-compliance, the petitioners mentioned that they tendered 18,088 polling unit results downloaded from IREF portal and they were admitted. Some were blurred and some showed pictures of unknown persons, yet INEC certified them. Labour Party mentioned that the INEC officials with respect must have a bizarre sense of humour to have done that. They mentioned that ordinarily the result on the IREF should be exactly the same with the hard copy and not blurred. They mentioned that the non-compliance affected 14 states and 168 local government areas as evidenced by the exhibit tendered. On issue 3 as regards the return of Bola Ahmed Tinubu and Shettima, they based their argument on the fact that Bola Ahmed Tinubu did not obtain up to 25% in the FCT. Labour Party argued that a holistic reading of Section 299 of the Constitution seems to suggest that the FCT will be considered as a state for the purpose of enjoying the executive, legislative and judicial powers vested in a state. Hence, the FCT is executively administered by the President. The National Assembly legislates, and the local laws of the FCT and the FCT High Court is the court with territorial jurisdiction in the FCT. They further submitted that FCT will be regarded as a state to that extent alone and no more. They argued that the Constitution gives the interpretation that a winning candidate must have 25% of total votes cast in two-thirds of the states in the Federation and the FCT, meaning that a winning candidate must obtain 25% in 24 states and also 25% in the FCT. They further stated that Part 2 of the second schedule lists the state of the Federation and the FCT is not included as a state. Conclusively, they respectfully urged the court to grant all their reliefs. That is what happened to what transpired in the written document of the Labour Party answering the final written address of the APC, Bola Ahmed Tinubu, Shettima and INEC. I'm going to keep you details updated, so please make sure to subscribe to this channel and you will have more updates. Thanks for watching.